as a governor of the state, an appointment exclusively in the hands of the executive. Now the question is, apart from the propriety and other things, what I feel is, a governor, though a constitutional post and is therefore not answerable to the judiciary or before the High Court or the Supreme Court, you cannot make him a party. But his actions are undoubtedly subject to judicial scrutiny even as governor. Please see the case of Rameshwar Prasad, where the Supreme Court very severely criticized the action of the then governor, Sri Bhuta Singh. Therefore, though governor is not made a party, there are certain functions which he has to perform within his discretion, particularly with regard to formation of a government where there is a single party doesn't have a clear majority. His action is subject to judicial scrutiny. Should a former Chief Justice of India be at the risk of such a criticism by the judiciary? This is, secondly, though as governor he will not be a party, invariably he becomes the chancellor of various universities, and his action as chancellor is amenable for correction before the High Court. Even in that respect, it is not desirable that a former Chief Justice of India should be appointed as a governor. But the most surprising thing is, I found some eminent jurists, senior advocates supporting it, saying, why not? Other day, I was watching a panel discussion where I think Mr. Raju Ramchandran was also there, or I don't remember. No, you never. No, let there be no mistake, I will tell the name. It is Sri K.T.S. Tulsi, the former Vice Chairman of the Law Commission of India. He suggested that a former Chief Justice, being a very learned man, very thorough in constitution, therefore he is the most competent person to be the governor of a state. If this argument is stretched to its logical conclusion, every High Court judge and every Supreme Court judge, because he is a constitutional expert, is the best person to occupy the post of a governor. And if this becomes the order of the day, every High Court judge and Supreme Court judge will be looking forward, well, why not I do something so that I will become a governor. I was reminded of the famous saying of the former Chief Justice of India, Chief Justice Hidayatullah. He said, we want forward-looking judges and not judges looking forward. That will happen if, as a rule, we say the judge of a High Court or the Chief Justice can be appointed as a governor. The point that I am making is, after retirement, let the judges of the higher judiciary be paid their full salary during their lifetime. But at the same time, invariably, the executive should not be in a position to offer any appointment or assignment to the judges. Or in the alternative, even if it is not practicable to put such a total ban, the idea that at least for a period of 2 years, there should be a cooling period when they should not accept any appointment, or there should be no appointment. This is a proposition which I was told, put forward by the former law minister, and today the persons who make this proposition themselves have violated it and have appointed a former Chief Justice of India as a governor of the state.
The cooling period becomes hotter than.
Another important aspect which I would like to very briefly deal with, Mr. Ganguly has dealt with it in great detail, is about this appointment of the judges to the higher judiciary itself is a very important subject. Now, between 1950 and 1993, though there was a provision for effective consultation with the CJI and other judges of the Supreme Court, it was only consultation and not concurrence as held by the Supreme Court earlier. Therefore, the ultimate power of appointment vested with the executive. The only limitation on the power was that you must have effective consultation. Now, as already stated, I don't want to repeat it. In 1993, in the second judge's case, virtually by way of interpretation, the Supreme Court rewrote the Constitution, particularly regarding the provisions regarding appointment. A totally wrong judgment. I should say that I had the privilege of arguing before the 9 judges in that case, as at that time I was the Advocate General of the state. So after 93, we have 21 years the system of collegium. Now we have found that both the systems have not worked satisfactorily. So far as the collegium system is concerned, my humble view is that the selections made prior to 1993, when the executive had the sole authority ultimately, were far, far better than the selections that have been made after 1993. But all the same, generally it is accepted that both these systems have failed. Therefore, the present law providing for a national judicial commission. My request is that the bar as a whole should welcome this. Now, regarding the present law, which is envisaged, earlier, the previous government only 2 years back tried to introduce the Constitution Amendment Bill along with a plenary legislation providing for composition of the National Judicial Commission. Because the government of the day thought if it is a simple legislation, by simple majority, they will always be there in power. They can meddle with the law. Therefore, the Constitution Amendment did not provide for the composition of the Judicial Commission, but it was only by way of ordinary legislation. So that was one criticism. When that legislation was introduced, there were real apprehensions. In fact, Sri Anil Divan himself wrote that it is a Trojan horse that is at the doorsteps of the judiciary. But today, the present amendment, the Constitution itself provides for the composition of the Judicial Commission, and in the present bill, which is yet to become law, though it has been passed by both the houses of Parliament, I personally feel that this composition of the Judicial Commission provides for proper check and balance, giving due representation to the judiciary, executive, as well as to the litigant public. Now, of the 6 members of the commission, 3 are judges, 50%. That too, Chief Justice and 2 senior-most judges, they are there. Now, executive is represented only by the law minister. Other 2 are eminent people. And I welcome the suggestion of 2 eminent people. It need not be a jurist alone. In fact, suddenly it came to my mind, an eminent person of the eminence of Abdul Kalam, who was a former president, or Sri R.M. Lodha, who was after retirement a former Chief Justice having very good name. Any such persons. And even in the selection of these 2 eminent men, the selection is by Chief Justice of India, Prime Minister, and the Leader of the Opposition. And you cannot normally expect them to select persons of any Tom, Dick and Harry, but it will be an eminent person only. Therefore, my suggestion is that this legislation regarding appointment of judges is worth trying. As against the two earlier systems, now the third system envisaged appears to provide for a proper check and balance, and therefore the bar should welcome it, and this will, according to me, ensure independence of the judiciary. Now, another aspect with that I conclude, which I would like to mention, is this legal aid program. Everywhere in the legal aid program, the judiciary is very much involved, which is not desirable. Now we have got the legal aid committees headed by the judges, both at the High Court level and in the lower court level, district judge, municipal, everybody. Now the grants are from the executive to the judiciary. So there is some sort of a connection. And how these funds are to be utilized, the judges decide about it. And for every function of the Legal Services Authority, judges of the Supreme Court are invited, but not all. Not of the category mentioned by Sri Ganguly. Only either those who are already in the collegium or about to get into the collegium. They alone are invariably invited for inauguration, and this sort of an action virtually gives a handle to the executive to interfere with the independence of the judiciary. Even at a lower level, the district judge or a munsif with relation to the legal aid program, he is compelled to come into contact with other wings of the government, the local authorities, as also the members of the public. It is not desirable that the judicial officers should be given such opportunity to mingle with other officials or the members of the public. So even in this matter, my submission is that if in the matter of legal aid program, it is not desirable that the judges should be involved, and involving the judges has in fact affected the independence of the judiciary. Now, only one other last point which I want to mention is regarding the present constitution amendment and the legislation constituting the Judicial Commission. One criticism which I found from many quarters is that even today morning a mention was made. All the political parties have joined together in this, and hurriedly within 2 days this legislation has been passed, virtually indicating some sort of a conspiracy among the politicians. But in fact, I may say, even before 1993 second judge's case, in the year 1990, the then law minister, if I am not mistaken, Sri Dinesh Goswami, he introduced 86th Constitution Amendment Bill. When the executive itself had the full power, the executive wanted to give up its sole power and have this bill. And that lapsed. And subsequently, Sri N.V. Gadgil again introduced a bill, private members bill, that also did not materialize. Subsequently, kindly see, Sri M.N. Venkatachalaya committee, which went into the review of the constitution, also suggested the constitution of a National Judicial Commission, which will serve the purpose. Thereafter, the second Administrative Reforms Commission, headed by Sri Veerappa Moily, they also suggested the constitution of this National Judicial Commission, and there has been long debates, so many articles supporting such a measure. Of course, with regard to the exact composition of the commission, there were differences, but in principle, it was always there. Therefore, today, if the legislation which was already contemplated, the parties agreed, and a acceptable formula has been brought, I submit it is not correct to criticize this legislation on the ground that it has been done in a great hurry. Therefore, it should be looked with suspicion. Thank you very much.
Thank you very much, Mr. Acharya, for your very interesting insights and your experience which you have shared with us. And this is certainly a subject on which there will be more than one opinion. But one thing is certain and central. Whatever you may say about the composition of eminent persons, the primacy must die with the judiciary. In fact, if I may remind you, someone mentioned Constitutional Assembly debates. I remember at that time, towards the end of it, Father Jerome D'Souza and others, they say we put our faith ultimately in the Supreme Judicature. They got the Judiciary Supreme Judicature. Whatever the faults may be of the judiciary, it's not a perfect institution, it has failed. EDM Jabalpur is a clear instance, there are other instances. But please remember, today even the faith of the common man is in the judiciary despite its imperfections, defects and deficiencies. If there's a commission of inquiry in a matter of national importance or public importance, the public man, the man says we want to judge. That's still the respect that the common man has for the judges, and I would request lawyers, particularly some, not to start a campaign of denigration of the judges. All the time, some judges, some lawyers can never say the judgment was erroneous, which I didn't have to say, it was dishonest. By that you really undermine the public perception of judiciary, and justice is rooted in confidence. And the best test, about Raju, I don't want to take your term, is I say, ask a common man even now on the streets, who would you like to have in adjudication of some dispute? This is a judge. Not because administrators and bureaucrats are not intelligent, they may be more, but the faith is in the impartiality of the judge. And let's keep that. Because after all, independence of the judiciary also lies in what the public feels about it. If the public feels it as an independent, then we don't have rule of law, you won't go to court of law, you settle your disputes by having the legal mafia come to your aid. So this is important, especially for lawyers to whom I appeal. Criticize the judiciary, it's not a holy cow. It can be criticized, but please be restrained in attributing motives and suggesting extraneous consideration in every judgment which has been decided against you or your client. Now, my great pleasure to ask my friend Raju Ramachandran. You know him very well, but I must tell you something about him. He accompanied me to the USA in the Union Carbide case. So we went from one city to another, and he was so particular about my diet that he saw to it, he knew I'm a diabetic, that I didn't eat or drink things which were very sweet and which would affect my health. And Raju has been a very independent person, even as the ASG me appointed him. And we look forward, Raju, to listening to your views on this very important subject, and especially the concept of the independence of judiciary.
Thank you, Chairperson, for your kind words. I want to strike a slightly different note. My emphasis will be slightly different from the previous speakers. Even otherwise, I'm different from the previous speakers because I'm not wearing a tie. And I was the only one who decided to take off his tie after the Chief Justice left. I would submit for your consideration that threats to independence of the judiciary come not just from the executive. Enough has been said about executive interference, both in today's session and in the current debate on the Collegium versus the National Judicial Commission. But equally important is threats from within, which Mr. Ganguly mentioned at the conclusion, and Soli also briefly highlighted, that judges should be independent of themselves. Now let us devote some attention to this aspect. Judges need to be independent of their own personal prejudices, their class interests, their sons and their sons-in-law, their daughters and their daughters-in-law. And that is why, if you remember, Chief Justice Lodha mentioned in the morning that in his interaction in the UK, he was told that the chairperson of the Judicial Appointments Commission there was a layperson, and even if the quality of the judiciary had not significantly improved, they were unanimous that transparency had been achieved.